Good morning, everyone. We'll get started as soon as courtroom 2 or ACDC gets on with us.
Good morning, Your Honor. This is quorum two. We're
Good
ready.
morning. Good. Where would you like to start this morning?
We can start with position number 9, Mr. Burke. Actually,
Okay.
no, not 9, Your Honor. Position number 12 and 13, Mr. Catalan.
Okay.
What's the number for your punishment?
Good morning, Mr. White. This is going to be a negotiated plea. Is that right?
It is, Judge.
Very good. Good morning, Mr. Catalan. Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Can you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down. Thank you, sir. Good morning, Ms. Tucker.
Good morning, Judge. Mr. Catalan is pleading guilty to theft by taking with the terms 12 months to serve 60 days, credit for time served 16 days, balance probated, to complete an anti-theft course, and to stay away from the Verizon Wireless located at 3530 Camp Creek Parkway. Position 13, his failure to appear will be null prost.
Mr. White?
Your Honor, we just asked that the probation terminate once he completes his anti-theft class.
Mr. Catalan, it's my understanding that in case 24 CR 004943Y, you wish to plead guilty to theft by taking. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
I do.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. Catalan. As soon as you complete the terms of the probation, it will terminate. So the sooner you get it done, the sooner you won't be on probation. Good luck to you, sir.
Thank you.
You're welcome.
Thank you, Your Honor.
Welcome.
Next, Your Honor, we can go to position number 14, Mr. Cross.
Also a negotiated plea?
It is, Your Honor.
Good morning, Mr. Cross. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Thank you for raising your hand for me. I appreciate it, sir. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Oh, yes, sir.
Okay, thank you, Mr. Cross. Ms. Tucker?
Yes, Judge. Mr. Cross will be pleading to count one, willful obstruction, with the terms 12 months to serve 32 days, credit for time served 16 days, balance probated, to pay a $300 fine, and to have a visit with a social worker prior to his release. On count two, criminal trespass, it's going to be 12 months to serve 32 days, credit for time served 16 days, balance suspended, and to stay away from the Chevron located at 2656 Donald Lee Hollowell Parkway in Atlanta.
White?
Your Honor, we would ask to convert the fine to 30 hours of community service. And we will be asking a social worker today when they get to the jail to go see him.
What was the obstruction, Ms. Tucker?
Let me pull it up real quick.
While she done, I take it there's an issue with housing, Mr. White?
Your Honor, he did not mention an issue with housing, so, but it's possible.
Okay,
He
so just so I'm clear, what is the social worker visit for?
That was the state's request, Judge, and I'm not sure.
So he ran on foot. That was the basis of the obstruction. And just the manner of the facts made the state think there was perhaps an issue there with housing.
Okay, if there is an issue with housing, then certainly I want him to get some type of assistance with that. So I'll keep the social worker visit in there. Given the facts of everything that I've heard, I'm gonna suspend the $300 fine. I'm gonna let him be done with this today, so it will be balance suspended.
Thank you, Your Honor.
All right, if nothing further, Mr. Cross, it's my understanding that in case 25 CR 0000839F, you wish to plead guilty to willful obstruction of law enforcement officers and criminal trespass, is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your plea, Mr. Cross. The court sentence is 12 months to serve 32 days. Credit for time served 16 days, balance suspended. On count one for the criminal trespass, 12 months to serve 32 days. Credit for time served 16 days, balance suspended, but you to stay away from that Chevron on Donald Lee Holloway Parkway, okay?
Yes, sir.
All right, don't go back to that. Don't go back to that Chevron. You're gonna be right back here. All right, we're gonna get you a social worker visit to assist if you need some housing also. I'm not sure if you do or not, but if you do, we'll try to help you, okay?
Thank you.
You're welcome. Good luck to you, Mr. Cross.
Thank you.
Next, Your Honor, we could go to position number 21 and 22, Mr. Fullen. Blue chair.
It's also a negotiated plea, Judge.
Thank you. Good morning, Mr. Fullens. I'm Judge Eric Morrow. This is the state all-purpose calendar. Can you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
You can place your hand down. Thank you, Mr. Fullens. Ms. Tucker?
Yes, in position 21, count one, battery family violence is going to be 12 months to serve 30 days. Credit for time served 11 days. Balance probated to have no further violent contact with Jasmine or Anika Harris, to have no firearms on probation, and to complete the Family Violence Intervention Program. Count 2, criminal trespass and damage to property will be 12 months probation concurrent with count 1, and position 21, that FTA will be null prost upon pleading.
Mr. White?
Your Honor, we would just ask that you waive 3 months of probation fees. This class would take upwards of 6 months to complete, and then does probation go to non-reporting upon completion?
Mr. Fullins, it's my understanding that in case 24 CR 001329F, you wish to plead guilty to battery, family violence, and criminal trespass and damage to property. Is that correct? Say it again. Do you wish to plead guilty to these two charges, sir?
Yeah.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Fullins. Although I can't waive any fees, I will have it go non-reporting once you complete the terms. So the sooner you get it done, the sooner you won't be on reporting probation and have to pay those fees. Good luck to you, Mr. Fullins.
Thank you, Judge.
Good morning, Judge. I have position 37 and 38, Ms. McLeod's case.
Okay, good morning, Francois. I hope you're well this morning.
Thank you. Hope you are as well.
Thank you. Ms. McLeod, good morning. How are you today?
Good morning, Your Honor. I'm very well. Thank you for asking. It is going to be a negotiated plea this morning for Ms. President.
Very good. Good morning, Ms. President. I'm Judge Eric Morrow. I remember seeing you at the SEA calendar. If you can raise your right hand for me, ma'am. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? You have to speak up a bit for me.
Yes, sir.
All right, thank you, Ms. President. You can put your hand down. Yes, Ms. Tucker.
Yes, Judge. On count 1, the criminal trespass is going to be 12 months to serve 35 days, credit for time served 17 days, balance suspended, and to stay away from the Efficiency Lodge at 4050 Wendell Street. And on the added count of a battery, it's going to be 12 months to serve 35 days, credit for time served 17 days, balance probated, an 8-hour anger management, 40 hours community service, and no further violent contact with LaTrenda Powell. And position 37, that FTA will be null prost.
Ms. Tucker, can you give me the case number on the battery? I don't seem to have it on my calendar.
Yes, so
With
it's
a
the
new
same,
charge added, Your Honor. It was just added.
correct,
Okay.
same case number.
Same case number. Okay, thank you.
That's been forwarded to voicemail.
Yes, Ms. McLeod.
Yes, Your Honor, that is our understanding. My client was particularly concerned about the no further violent contact. She wanted it to be that way because there was an incident between her and the alleged victim, but they do not have any kind of history of violence at all, Your Honor. And she did want to be able to maintain contact. This incident happened in 2023, and everything has been going well for her since then. So.
Okay. Ms. President, it's my understanding that in case 23 CR 005499H, you wish to plead guilty to criminal trespass and battery. Is that correct? Yeah, you're gonna have to get a little closer to the mic for me.
Yes, sir. Yes, sir.
Okay. Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with her representation? Say it again for me.
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced you or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. President. When you complete the terms of the probation, I'll have it terminate. So the sooner you get it done, the sooner you're not going to be on probation and have to pay those fees, okay? Good luck to you, ma'am.
Thank you, Your Honor.
You're welcome.
Judge, I'm also waiting for, Public Defender, Mr. Alex Chatea.
Okay, looks like he's logging on right now. So as soon as we get him, I will, is he gonna need to go into a breakout room or something?
Yes, he still needs to speak to, somebody here at ATDC. Okay, I see.
He's in the courtroom.
I'm right here, Your Honor.
Oh, okay, I'm sorry. I see you down on the, good morning, Mr. Shataya. Let's see, do you need to call, ACDC or how would you like to make that
So I'll
work?
go ahead and give them a call in courtroom too, Judge.
Okay, very good.
Thank you.
Who do we have next?
Your Honor, we have one of Mr. Chata's client, position number 31, Mr. Longino.
Okay, do you want to take this one before we have him on the phone, or how would y'all want to? I know he can't be in two places at once.
Yes. He'll take this one before going on the phone.
Okay, very good.
That's.
Good morning, Mr. Longino. Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Can you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, thank you, sir. You can place your hand down. Ms. Tucker?
Yes, Judge. Mr. Longino will be pleading guilty to simple battery with the terms 12 months to serve 32 days, credit for time served 16 days, balance probated, to complete a family violence intervention program and have no further contact with Glovia Hawkins.
Chataya?
This is a negotiated plea, Your Honor. I just asked that we go to non-recording probation once FIP is completed.
Okay. Mr. Longino, it's my understanding that in case 22 CR 002627C, you wish to plead guilty to simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
I signed a straight around, program. Keep going.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Does he require any additional services, to your knowledge, Mr. Chataya?
Now, I'm talking to you.
No, Your Honor.
That's why you talk.
Okay. Again, I will accept the plea as negotiated. As soon as he completes the terms of the probation, it'll go to a non-reporting status. Good luck to you, sir.
Yeah.
Hey, Alex.
Yes.
Just let me know when you're gonna be available so that I can call you.
Call the courtroom on the other phone.
I can't hear you.
Call the other phone, Francois.
We're going over.
I probably didn't receive no mail or letter to homies, and I didn't see no mail or letters, but I think they come that out too. I think they had both from when I was on that preacher.
Your Honor, if Ms. McLeod's ready with her position number 44, Mr. Simmons, hey, Bibbs, lower your voice.
Okay. Ms. McLeod, what are we doing with Mr. Simmons?
Your Honor, Mr. Simmons is going to be a non-negotiated plea.
Okay, what's the problem?
The state is offering 60 days credit for time served 24 days. And we're trying to see if the court would consider giving him the credit for time served instead of the 30 days. The state wants him to serve 30 days instead of he's only served 24 days so far. My client is trying to get out today if it is possible. So that is the only part of it. That's non-negotiated.
Okay, let me hear the facts and get the history before I make a determination. Mr. Howard, or who do we have from pretrial this morning?
Yeah, I'm here. I gotta pull it up.
Okay, good morning. So while he does that, Ms. Tucker, can you tell me the facts, please?
Yes, Judge. This incident occurred on February 8th of this year. Police responded to an aggravated assault call. When they arrived, he had been stabbed by the victim with a knife, but it turns out she had stabbed him because he had hit her multiple times, causing snatching her wig off and leaving marks. They do live together and they reside at the same that's what lives together means. 60 days is serving 30 days. By asking for 60, you know they get 2 for 1. So we're only asking for 6 more days. And we actually attempted to transfer this case based on the history, but they did not accept it.
That's a good reason why they did not accept the case. I have not seen all of the discovery, but I certainly have had the opportunity to see the warrant. And it is evident, even from the warrant, that the alleged victim was a primary aggressor. This was a dual arrest situation. She was also arrested. I took the opportunity to do some research on the victim, and she has significant history herself. She also has a history of domestic violence herself and of also making allegations against other people. For example, she has an ex-husband who has had TPOs against her, and where she's tried to get TPOs against him. She also tried to get a TPO against my client, and this was dismissed yesterday because she didn't show up for one thing, and I could just see, just from looking obviously, that she has a history of being messy. And the warrant itself says that she stabbed my client and that he was bleeding when the police officers arrived on the scene. I think someone who's related to her tried to tell the police that, yes, it was because he pulled her wig first or something like that. But my client tells me that that is not what happened, Your Honor. And I think he spent enough time in jail behind something like this. They are not in a relationship anymore. It was something very, very brief because I did see that her divorce took place in September of last year. He tells me it was just a very, very short situation and he just wants the opportunity to go with a police escort to get his belongings so he can leave, and he does not wish to have any further contact with this person, Your Honor. So I think it's not unreasonable for him to get out
And
based on the time he served.
And Judge, if we don't get a history from pretrial, he does have a very violent history with a battery family violence case out of 2018. That was the basis for us trying to transfer it to the DA. He's got another battery in 2018 that was null prost. He's got a simple battery family violence out of 2020. That was null prost. Another simple battery, 2021. That was a conviction. He's got a DUI. He's got and a simple assault and simple battery out of 2023. So based on the history, I don't think 6 more days is that unreasonable. We're asking for in total. The simple battery will merge. The battery family violence is 12 months, served 60 days, credit for time served 24 days, balance probated to complete the FVIP program, complete 40 hours of community service, and have no further contact with Tracy Aston. And on the cruelty to children, 12 months, served 60 days, credit for time served 24 days, balance probated, and an additional 20 hours of community service. So there will be 60 hours total.
My client is amenable to all of those conditions, Your Honor. This is a dual arrest. She was arrested as well. And the warrant clearly states that he was bleeding when they arrived. He was the one who called the police. Just because someone has a history doesn't mean they're always the aggressor. Sometimes it's the other way around. And the alleged victim also does have some history herself.
Well, I totally agree with you, Ms. McLeod, but if he's gonna plead guilty, that's a whole different story. If he's pleading guilty to battery family violence, that means that he committed battery family violence. Now, if he doesn't want to plead guilty, I'm happy to look at the bond there, but if he's going to plead guilty, that means to me that he's accepting responsibility, that he's saying that he did it, and that he's going to accept the consequences for what he did. Now, if he's trying to tell me, which is what it sounds like that you're saying to me, that he really wasn't the primary aggressor and that he really did not commit battery family violence, then maybe he would want to have his day in court in that regard, and I can take a look at the what the present bond is. But as far as if he's going to plead guilty and accept responsibility based on his history, I'm going to accept the state's recommendation. So let me know what you'd like to do, given what my ruling is going to be.
Your Honor, my client told me that he would take it even if the court said he had to stay for the full time, Your Honor. So that is what we're going to go with.
Okay, is that correct, Mr. Simmons? You would like to plead guilty to this battery family violence and cruelty to children?
So,
Is that a yes? I'm sorry.
yes, Your Honor.
Okay. Anything further before I take the plea?
He would
If not-
need a one-time police escort back to the location to get his belongings, Your Honor. We're asking for that.
Okay. Mr. Simmons, it's my understanding that in case 25 CR 0000689J, you wish to plead guilty to battery family violence and cruelty to children in the 3rd degree. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea for the battery family violence, 12 months to serve 60 days, credit for time served 24 days, balance probated, the family violence intervention course, 40 hours of community service, no further contact with Ms. Austin. For the cruelty, 12 months to serve 60 days, credit for time served 24 days, balance probated, an additional 20 hours of community service. I will allow you to have a one-time police escort to retrieve any belongings from the location. And let's see, when you complete the terms, I'll have it go to a non-reporting status. Good luck to you,
Thank you,
Mr.
Your Honor.
Simmons.
Yes, sir. Thank you.
Thank you, Your Honor.
You're welcome.
Excuse me, Judge, just to be certain, the simple battery is merging with the battery, correct?
Yes.
That's my understanding, yes.
Thank
We have next.
Your Honor, I have a few Kim's clients currently speaking to her COB right now. And I
Say that one more time for me.
said I have a few pleas for Kim, but
Okay,
she's currently talking to one of her clients in the courtroom.
okay. So you'll just let me know when you're ready to proceed. I guess we'll be in recess until someone's ready to go, okay?
Make a couple announcements in the meantime.
Okay,
Positions 3 through 6, we're going to need to reset that case to 3:13, the 11 o'clock calendar.
so the 13th, is that what you said? I'm sorry, Mr. White?
Yes, Your Honor.
Okay, 11 o'clock on calendar, so that's Mr. Bibbs. Okay,
In position 10, Mr. Campbell is going to be a waiver.
okay, we don't need Mr. Campbell.
And
Okay.
position 11, the state had a to be determined on there. I wonder if they have anything further for us.
So Shelly is gonna hop on after she gets out of her meeting. She'll be here before the end of the calendar. That was one of her cases. So I
Okay.
would wait and defer to her.
No worries.
Your Honor, I have a case. My client, I believe, is probably in medical still. It's position number 18, and I would like to visit his bond, the issue of his bond, Your Honor.
Okay, well, will we have him here this morning?
He did, medical, Your Honor.
Okay, so we're gonna see him while he's in medical or,
Yes,
okay, okay. So we'll do that as soon as we get medical on the line, Ms. McLeod.
Yeah.
Yeah,
Do you also, Ms. McLeod, have position 39, Price?
Mr. Price. Just a moment, Your Honor. I will.
I just see a conflict attorney by his name. There's not a conflict, a name listed, so I just wanted to make sure if it wasn't yours that we figured out whose it is.
I will check to see, Your Honor, if he's one
Okay.
of my clients.
Thank you.
You're welcome.
Your Honor, I have two announcements to make if I may.
Yes, of course. Go ahead.
Position 23, that's going to be a waiver of appearance, not guilty.
23.
Ms. Horst.
Okay. And Carolyn Ford is a waiver. Position 23. Okay.
Number 40 is going to be a reset for next week.
40. 41.
I'm sorry, 40 and 41 are being reset to when?
1 week from now
Is that the 11th?
to the 11th, right?
Okay, so we set to 311.
Your Honor, Mr. Price is my client. I just haven't spoken to him yet. I'm going to need to speak with him.
Okay, thank you, Ms. McLeod. We'll make that happen.
we can use that. Alright, yeah, I do. Okay.
Okay, we'll be in recess until someone's ready.
Alright,
Position number 18, Mr. Drake, he's a conflict.
Okay, this is Miss McLeod's client.
That is correct, Your Honor.
Okay, good morning, Mr. Drake. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Good morning, sir. It's my understanding that Ms. McLeod, you wish to make a bond modification argument on Mr. Drake. Is that right?
It's correct, Your Honor.
Okay, Mr. Howard, may I have Mr. Drake's history, please?
Let's see. He on probation out of Elbert County, possession of a firearm by a convicted felon or felony first offender. All right, hold on. What is his history? Hold on. He got multiple out of state history.
Any? Okay.
So he's been in custody since January. What's it? Simple battery DV? Yeah.
Yeah.
2024 probation. That's the convicted felon. More 2024 probation. It's a 2019 simple battery DV arrest. I'm not sure the disposition. I can look it up real quick if you want to.
If you could, please.
1909673.
Your Honor, for full disclosure, I had a bond modification hearing on this case last week, and my client was given a signature bond, but it was conditioned on an ankle monitor. And that is the issue that I need to revisit because my client is indigent and cannot possibly afford the cost of the ankle monitor.
Who was the judge on that?
The judge was Judge Lawley, Your Honor, and there's a lot of background to this story.
So why don't we do this, Ms. McLeod? I don't mean to cut you off, but given that it's Judge Law's bond and conditions, why don't we reset him for Thursday and let her consider that instead of me? I feel more comfortable with that since she's already heard this before and since she was the one who thought that he needed an ankle monitor. Is that satisfactory with you? And we can reset it for Thursday.
Yes, Your Honor. I just want to get my client out of jail, Your Honor, because he is in pretty poor medical state. He was stabbed several times by the alleged victim. He was in Grady for over a week. He's still in medical at the jail 3 weeks plus later. When I went to see him on Saturday, he could show me the huge bandages he has all around his torso. He really does not need to be in jail.
He got a 2019 ag assault strangulation conviction, not a superior court.
Okay. Thank you, Mr. I'm going to let Judge Law reconsider it, just given that it's her bond and she thought that he needed an ankle monitor. So we'll put him back on for Thursday. We'll see you back on Thursday, sir.
Position 39, Mr. Price.
Yes, Your Honor, there is an issue with Mr. Price, and I realize now why I was unable, I did not enter appearance for him, even though I represented him at his first appearance, because I did a conflict check and realized that I do have a conflict because the alleged victim, Carlos Peterson, is someone that I previously represented.
Okay.
Mr. Peterson is in jail as well at this time, Your Honor.
Okay, so we need to get him another conflict attorney.
That is correct, Your Honor.
Ms. Strong.
I'll reach out, Judge, to see who else.
Okay, thank you. So if Mr. Price, good morning. If we can find another conflict attorney for you today, then I'm happy to have them speak with you and proceed with your case. If not, I'm going to reset your case for Thursday so that someone can speak to you part of that time. Okay, we'll try this morning to see if we can move this along. Okay?
Okay.
All right. Thank you, Mr. Price.
Ready, Your Honor.
Thank you, everybody.
Okay, good morning, Ms. Kim.
Good morning, Your Honor.
We can start with position number 45, Mr. Snell.
Okay,
This is.
that's in the negotiated plea, Ms. Kim?
Yes, Your Honor.
Very good. Good morning, Mr. Snell. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Can you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can place your hand down. Thank you, Mr. Snell. Ms. Tucker?
Yes, Judge, he's pleading to one count of criminal trespass with the terms 12 months to serve 34 days, credit for time served 17 days, balance suspended, and to stay away from all Georgia Tech property.
Ms. Kim?
Yes, Your Honor. We stipulate for the purpose of the plea.
Mr. Snell, it's my understanding that in case 25 CR 0000834J, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Not
You've been represented by counsel. Are you satisfied with her representation?
completely.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
It's not that, Your Honor.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Snell. Good luck to you, sir.
Position 15 through 17, Curtis.
And Ms. McLeod, do you need to speak with Mr. Curtis?
I do, Your Honor.
Okay, can we place medical and Ms. McLeod into a breakout room, please?
Okay, Judge.
Thank you, Ms. Grace.
Next, Your Honor, we have position number 46 and 47 for Washington.
This is also negotiated plea, Your Honor.
Very good.
What numbers with this?
This is 46 and 47, Mr. Marvin Washington. Good morning, Mr. Washington. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Say again for me. Okay, I'm a little difficult hearing you, so put your hand down. Thank you, sir. Ms. Tucker?
Yes, Judge, in position 46, Mr. Washington will be pleading to battery with the terms 12 months to serve 18 days, credit for time served 9 days, balance probated, to complete the 12 weeks of anger management, 40 hours of community service, and to have no further contact with Terry Brown. Position 47, the FTA will be null.
Ms. Kim?
Yes, we stipulate for the purpose of the plea, Your Honor.
Mr. Washington, it's my understanding that in case 24 CR 0010003A, you wish to plead guilty to battery. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
Okay.
You've been represented by counsel. Are you satisfied with her representation? You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Mr. Washington, when you complete the terms of the probation, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation and have to pay those fees, okay?
Okay.
All right, good luck to you, sir.
Thank you, Your Honor.
Welcome.
Next, Your Honor, we can go to position number 52, Mr. Woods.
This is also a negotiated plea, Your Honor.
Okay. Morning, Mr. Woods. I'm Judge Eric Morrow. This is the state all-purpose calendar. Can you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can place your hand down. Thank you, sir. Ms. Tucker?
Yes, Judge, Mr. Woods will be pleading guilty to simple battery with the terms 12 months to serve 30 days, credit for time served 15 days, balance probated, to complete a 12-week anger management course, 40 hours of community service, and have no further contact with Lemetria Trammell.
Ms. Kim?
Yes, we stipulate. Can he also have that being after, probation is over?
Okay. Mr. Woods, it's my understanding that in case 25 CR 0000855F, you wish to plead guilty to simple battery, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Woods. When you complete the terms, it'll go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation, okay? All right, good luck to you, sir. Who do we have next?
We can go to position number 25 and 26, Mr. Jackson.
This will be non-negotiated plea, Your Honor. My client wants to know if he can get the balance suspended, or if he has to have a probation, he would like to reduce jail time.
So, Ms. Kim, he has, just so I'm straight, he has an objection to doing the anti-theft course and paying $300.
Those
Fine.
section. If he wants to reduce his jail time the most.
So you finished?
Yes.
And this is Mr. Steven Jackson.
Yes, Your Honor.
So I have for Mr. Jackson that the recommendation is 100 credit for time served, 50 days, 100 days credit for time served, 50 days.
Oh,
Correct.
correct, Your Honor. He wants to have a no probation, Your Honor.
Okay, well, so what I said to begin with, he doesn't want to do the anti-theft class when he doesn't want to pay the $300.
Yeah, I'll pay the money, I don't wanna be on probation.
Well, you have to be on probation if you're gonna, so we can monitor you until you pay the $300 and until you do the anti-theft class, you have to be on probation so we can monitor you. As soon as you're completed with those classes, I'm gonna terminate the probation. So if you get it done in the first month, then you're not gonna be on probation any longer.
It's gonna impact that.
Yes. Your Honor, he wants to reset to next March 11, 2025.
Unless he can do the $300, you're fine. Wait.
So you want to stay in jail for another week when you can get out of jail today?
He cannot get out of the jail anyway, Your Honor.
Oh.
Because there's another case. He has a arraignment for a felony charge on March.
Oh, okay, all right. So we'll reset till 3/11.
Yes, Your Honor.
You want to be put out now? You about to go anyways.
Thank you, Your Honor.
You're welcome.
Your Honor, we can go to position number 36, Mr. Park.
This is waiver of arraignment as well, so I'll file the paperwork and get back to you. I'm sorry.
Okay, so Mr. Parks, position number 36, case will be returned to the division judge and he'll get notification of his next hearing date.
Yes, Your Honor.
You can go to position number 32, Mr. Marshall.
What are we doing with Mr. Marshall?
This is plea deal, negotiated plea deal, Your Honor.
Okay. Good morning, Mr. Marshall. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Can you raise your right hand for me, please, sir? Do you swear to tell the truth, nothing but the truth?
Yes, sir.
Okay, you raise your hand down. Thank you, Mr. Marshall. Ms. Tucker?
Yes, Mr. Marshall will be pleading to simple battery with the terms 12 months to serve 36 days, credit for time served 18 days, balance probated, to complete an MHET, to complete 12 hours of anger management, to have no further contact with Daniel Cullen, and to stay away from the Drury Inn Hotel at 1270 Virginia Avenue in East Point.
Ms. Kim?
Yes, we stipulate for the purpose of the plea, can probation be terminated upon completion of 12-hour anger management, Your Honor?
Okay, I'll have it go to a non-reporting status, Ms. Kim.
Thank you, Your Honor.
Okay, Mr. Marshall, it's my understanding that in case 25 CR 0008258A, you wish to plead guilty to simple battery, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by Ms. Kim. Are you happy with what she's done for you?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Marshall. When you complete the terms, it'll go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation, okay?
Yes, sir.
All right, good luck to you, sir.
Can we go back to position 15 through 17, Curtis?
Okay, what are we doing with Mr. Curtis this morning?
This will be a motion to modify Mr. Curtis' bond.
Okay, so you will also file a waiver?
Yes, Your Honor. I've already filed a waiver into that case.
Oh, okay. Let's see, Mr. Howard, may I have Mr. Curtis's history, please?
Yeah, I gotta pull it up.
Okay, and Ms. Tucker, would you tell me what the current bond is in the facts?
Your Honor, I'm
Oh.
here.
Oh, hi, Ms. Fall.
Hi, sorry for running behind. I had a supervisor's meeting I had to attend. So currently the defendant has a $2,000 bond, $500 on the failure to appear, $1,500 on the newest family violence battery that he has, and 2 holds from foreign counties, one from DKSO, DeKalb County Sheriff's Office, and one from Union City. Usually the pretrial services is able to assist me with what the foreign hold is actually for, because the information that I'm seeing in the hit confirmation doesn't tell me what the active warrant, well, one of the active warrants, the one out of DeKalb, it says it's for larceny. But I don't know what the Union City hold is for.
You able to assist with that, Mr. Howard?
It's an FTA warrant, just says FTA. They didn't print the IQ, so I don't know what the underlying charge was. But it's a FTA out of Union City, FTA out of DeKalb County. He has an open case in DeKalb for theft by taking. So that might be what that DeKalb one is for.
And the FTA here was for a bench warrant from October 6, 2023, where Judge Law issued a bench warrant for his failure to appear at a status conference on that same date.
Okay.
So that is 3 FTAs that he currently has, 2 from 2 other counties, and then 2 from 2 other locations, and then 1 from here.
Or voting.
Okay. Ms. McLeod?
Your Honor, I would ask the court to modify my client's bond to a signature bond. Of course, it can be conditioned in him being released to these holes that he has. There are a number of reasons why I'm making this request, Your Honor. As you can see, he is in medical, so he does have some medical issues which are better addressed if he's on the outside. Apart from that, when he had his first appearance, Your Honor, the alleged victim, Mr. Aaron Bowden, was on, and he made it very clear to the court, this was a dual arrest actually, that he had no issues with my client. He was concerned with the cross defendant and did not want that person to come back to the household. I also want to point out that my client was not in a relationship with the alleged victim. He just lived in the household, and the alleged victim made that very clear that he had no problems with my client coming back there and with having contact with my client. It was more with the other person who was arrested, and that was on the first appearance, which was broadcast on YouTube. My client, even though it's not a very high bond, he's just not in a position to pay for bond, Your Honor, and that's why he is still in jail. So I'm asking the court to consider giving him a signature bond. Nothing further, Your Honor.
What is his current bond on the battery?
On the battery, it's $1,500, Your Honor. That was signed by Judge Mincy. I believe that was due to, well, one, he wouldn't be eligible for a signature bond because of his history of FTAs. Under the statute, he would not be eligible for a signature bond. So I believe that is a portion of the reason, as well as the fact that the defendant also had an open theft by taking at the time he committed this offense, which also had an FTA associated with it. The defendant has been arrested 9 times. This is his 9th arrest. He has the FTA, a previous arrest for theft by taking in DeKalb County, a previous arrest for theft by shoplifting in Union City, which I believe that's the FTA that's based on. That was from January 1st of 2023. A theft by taking in Fulton County, I believe, let's see, that 22 CP case, and our theft by taking, and then a 2020 theft of services and a driving while license suspended in 2016 and 2015. The theft by taking that was in Superior Court, it looks like was closed. It was dismissed. But the other theft by taking is still open. It looks as though on the theft of services, that was dismissed. And then he had a theft by receiving stolen property case that he pled guilty to in October 13th of 2022. So I think that based on the number of offenses that he's had since 2020, as well as the number of FTAs he's had since 2020, that he would be a poor risk on bond under the Ayala factors. And I believe that's the reason a $1,500 bond was issued.
Okay. It'd be one thing, Ms. McLeod, if he didn't have a history of FTAs, but he's got a significant history of FTAs. I think that these bonds are in line with his FTAs. I'm not willing to modify them at the present time. All right. Good luck to you, Mr. Curtis. Who do we have next? And Ms. Falk, if you would take a look for me and Mr. White at position number 11. I believe there was a question about a state's offer in that case that Mr. White wanted to address at some point.
It will be turned across on that, Your Honor.
Okay. Did you hear that, Mr. White?
No objection.
What
Okay.
position was that?
That's
Defino
position
Castanon, it's position 13.
And then
Oh, position 11, excuse me.
7, yes. Okay, who do we have next?
Number 9, Burke.
Mr. White, this is a negotiated plea.
It is, Your Honor.
Good morning, Mr. Burke. I'm Judge Eric Morrow.
Good morning.
Good morning, sir. This is the state all-purpose calendar that we're conducting by video. Can you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, sir. Yes, Ms. Fall.
And Your Honor, this is position number 9.
Yes, Mr. Burke.
The state's recommendation on Mr. Burke is 12 months served 30 days, credit for time served 15 days. That is from February 18th of 2025 until today. Balance suspended. Stay away from the Burge Apartments located at 125 Milton Avenue Southeast in Atlanta. We do ask the defense to stipulate to venue factual basis and identification for the purposes of this plea. That's all for the state.
Your Honor, we do stipulate, we would just ask to enter this as a NOLO plea.
Let me just take a look at his history really briefly and see if he has entered a NOLO plea previously in the last 5 years. Your Honor, he is not. He would be eligible.
Okay,
And the state doesn't object.
very good. Thank you. Mr. Burke, it's my understanding that in case 25 CR 0000859E, you wish to plead NOLO to criminal trespass. Is that right? You have to answer verbally for me, Mr.
Yes,
Burke.
sir. Yes, sir. Please.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir. Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading NOLO to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead NOLO?
No, sir.
I'll accept the NOLO plea as negotiated, Mr. Burke. Good luck to you, sir.
Thank you, sir.
Thank you, Your Honor.
Who do we have next?
Position number 35, Mr. Moore. Sorry, Your Honor, Kim has stepped out. We can be in recess.
Okay, we'll be in recess until someone else is ready to go. Mr. Chatai, are you there?
I'm right here.
Yes, a couple of your cases that you wanted resets for. Position number 27, Mr. Jarrett, when would you like that reset for?
Next Tuesday, March 11th.
Okay, so 27 Jarrett will be 311 reset. Position 33, Mr. Marshall,
Marshall,
Aaron Marshall.
likewise, next Tuesday, March 11th.
Okay. 33 will be set 311. Positions 42 and 43, Chantel.
Could we reset that to next Thursday? March 13th.
313, would you like that on the comp calendar?
I'd like to have a social worker visit her first before sending her to the comp calendar.
Okay, so 313 for position 42 and 43. Okay, thank you. I think that's all of them.
Your Honor, Kim is back. We can go to position number 35, Mr. Moore.
Thanks, Your Honor.
What is missing?
Oh, this is gonna be non-negotiated, plea, Your Honor.
Okay, position number 35. What's not negotiated about it?
He would like to reduce the jail time so he can keep his job. He has, one of the best job, ever since, he was released. He does not want to lose his job.
Mr. Howard, may I get the history, please?
Open ag battery in Superior Court. Let me give you the case numbers. 24 PI 002-407. What is history? They got history out of the state of Washington. What else? And Georgia. 2018 probation. Got an ag assault conviction from 2018 out of Alpharetta. It's 18 SC 163-844. False imprisonment and kidnapping was dismissed. 2015 simple assault conviction. Criminal damage to property, second degree conviction, 2015. Shoplifting. I can see a 2005 simple battery conviction. You want me to go back that far?
Okay, so nothing since, so he's got this charge and the aggravated battery that's open.
And the ag assault from
And the
2015.
assault, 20.
From whatever y'all told you. What did I say,
Okay,
2015?
all right. Yeah, well, you said 2018.
2018
Aggravated
then.
assault.
Okay.
Okay, all right, thank you. Ms. Tucker?
Yes, Judge. You did history. He has that violence in the history as well as he's got that open aggravated battery. The facts of this case are also alarming. He was at the Anytime Workout Fitness Gym. He was in a dispute with the worker there. He wanted a refund. He didn't qualify for the refund, so he slapped him in the face, causing redness to his face and neck. So the fact that this is, not a random act of violence, but it's against, a stranger really, as well as the violence in the history. I believe that the state's offer is reasonable. As you know, there's the 2-for-1, so asking for 90 days is really like asking for 45 days. The state's offer is 12 months to serve 90 days, credit for time served 16 days, balance probated, 12 weeks of anger management, 40 hours of community service, no further contact with Andrew Smith, and to stay away from 1715 Howell Mill Road in Atlanta. That's that Anytime Workout Fitness Gym. And this disorderly conduct will merge.
Your Honor, ever since his father passed away on 2021, he has been a major financial provider for his elderly mother, who's also disabled. So it's very important for him to keep a job. And so we would like to know if he can get less jail time, Your Honor.
I dealt with Mr. Moore in at the SAP calendar, so this is familiar to me at that time. Mr. Smith was there and gave me the history or as to his account as to what happened. I hold on for me, Mr. Moore. Listen to what I have to say before you want to interrupt me. If I'm going to let him out early, I'm going to require that he has some mental health evaluation and any treatment that's necessary. I'm going to require the 12 weeks of anger management. I'm going to require not 40 hours of community service, but 100 hours of community service, along with the no further contact and the stay away. So it will be 12 months to serve 32 days, credit for time served 16 days with the other stipulations that I've put on the sentence. You want to discuss that with him, Ms. Kim?
Yeah, yes, sir. I just thank you for, yes, sir, thank you. That's one that's all.
He's willing to take it, Your Honor.
Anything further before I take the plea?
So I lost my couple of things. Money, good money. I'm not gonna get. So how would I got that? Because it's gonna be 2 weeks.
And he have a 1 month probation fee waived because he's gonna take another 2 weeks for him to pay. So he want to make sure he can pay for the probation fee.
I mean, I have no.
And Judge, just briefly, just to make sure we cover all our bases, because the victim was there at SAA, would you sound to see if he's on to this hearing? It's Mr. Andrew Smith.
Mr. Smith is on the line and wishes to address the court. Now is your opportunity.
Thank you, Judge.
All right, so Mr. Moore, it's my understanding that in case 25 CR 0008458, you wish to plead guilty to battery, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
Sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your guilty plea, Mr. Moore. The court sentence will be 12 months to serve 32 days, credit for time served 16 days, the balance probated, 12 weeks of anger management, 100 hours of community service, no further contact with Mr. Andrew Smith, stay away from the Anytime Workout Fitness Gym on Howell Mill Road. I will waive 1 month of probation fees to help you get on your feet. When you complete the terms of the probation, it'll go to a non-reporting status. So although you'll still be on probation, you won't have to report and pay those fees. All right. Good luck to you, Mr. Moore.
Positions 40 and 41, Ms. Janice Ruff.
Your Honor,
What do we-
this is a reset.
Okay. Positions 40 and 41, that is Ms. Ruff is going to be reset until March 11. So I'll see you back on March 11, Ms. Ruff. Mr. Chataya will speak with you, ma'am. He'll talk to you before that time. Okay? Anyone else in courtroom 2 that we can take right now?
Yes, we can go to position 50 and 51, Mr. Woodard. That's Kim's client.
Yes, Your Honor.
So I take it that you have proof that he was incarcerated?
Yes, we do. Actually, I have a paperwork right there.
Okay. Okay. Good morning, Mr. Woodard. You can go ahead and put your hand down. Thank you, sir. I appreciate it. I appreciate you being proactive for me. Let's see. So if we can get, it's my understanding that Mr. Woodard was incarcerated when he received the FTA. Have you gotten that paperwork, Ms. Tucker?
No.
Okay,
I can send it out right now. When-
Yes. If we could just get a copy of that, then I'm sure we can now process the FTA. And it's my understanding that's the only thing that's holding him.
Yes. Let me go get my laptop so I can do it right now.
Okay.
okay. So, Mr. Woodard, when they get the paperwork, given that you were incarcerated, they're going to null process or dismiss that FTA. So you'll be able to get out and come back and deal with these charges at a later date, okay?
Thanks, Your Honor.
Okay. Anyone else in courtroom two that we can take?
Anybody?
I'm calling me a Spanish interpretation.
Strong, Ms. Strong, are you with me?
Yes, sir.
So for position 39, Price, I take it we're not able to find a conflict attorney for today?
Miss Grace was reaching out to see if she could find someone.
No,
Okay.
sir, I'm still trying. No one is available as far.
Okay, so it appears that we're going to have to reset him. I don't want him to, it looks like this is a time served offer, so can we reset position 39, Mr. Walter Price, until Thursday? Hopefully we'll get a conflict attorney by then. 3-6. Ms. Kim in the courtroom there? Kim, could you unmute your?
Yes, we're here.
Okay, you need to check status on 55 and 56. That's Mr. York. Have you had the opportunity to speak with him yet?
Yes, actually, I spoke with him. Only thing is though, he has 3 other cases that we don't have answer from solicitor's office, whether they're gonna be all combined and have a global recommendation.
I'll have to look into that. I didn't note any additional cases. I typically catch up on that or catch those. But I didn't see them attached. Do you have those case numbers?
His
Yes.
other cases are reset for SAP on Thursday, so I think that was Mr. Jordan's question. I'm not sure who he asked. But if we wanted to just reset the cases that were on this calendar to be heard on Thursday with the other cases that are already on that calendar.
I think that makes sense, Your Honor.
Okay, so Ernest York, 55 and 56 will be reset until 3/6. Thank you, Ms. Strong. Also, Ms. Kim, yours is position 49. Mr. Williams, have you had the opportunity to speak with?
Not yet, Your Honor. I'm still waiting for him.
Okay, so we're waiting on Mr. Williams, 49. Mr. Chataya, Mr. Jones, position 28. We're waiting to take a no-low plea on that. Is that right?
Let me just check my notes.
I believe so, Your Honor.
Oh, let me check.
But Mr.
Yeah, yes, that's supposed to be a no-low.
Okay, and we also need position 24, Mr. Hughes. You're gonna take a plea on that as well. Mr.
Yes, that's negotiated.
Okay. Did I miss any? Are those the only ones that we have left to deal with this morning? Ms. McLeod, do you have anything further this morning?
Further, Your Honor.
Okay. I'll see you
Your Honor,
next. I'm happy to keep you here, Ms. McLeod, but you're free to go if you.
I'm
you got
done
other
for the day.
business. Okay, have a good day.
You
Yes,
too,
Ms.
Your Honor.
Fox. Thank you.
If I may ask PD Chatai, on position 24, is he pleading to the add-on as well, or just the case on the calendar? It is a global recommendation.
He's pleading to both, but he can't plead no to both, right?
That is correct. He cannot plead no-low to both.
Okay, then I'll just have to talk to him when he gets here.
Okay. Your Honor, is it at all possible we can just go over the calendar just so I can catch up?
Okay. Yeah, that's fine with me. If that's okay with Ms. Strong,
If
is that
we're,
okay
if we're
with you?
waiting for defendants to come down.
Sure.
Position number 1 was, 1 and 2 waived arraignment. Position number 3 is reset for SAP competency calendar on March the 13th. Also that's the announcement for 4, 5, and 6. Position number 7 is reset for SAP for next Tuesday, March 11th. 8 is reset jail jury. 9 was a plea. 10 reset jail jury. 11 was
And
no.
Ms. Strong, I'm so sorry. If you could just slow down just a
Oh,
little
I'm
bit,
sorry.
because I'm typing these in as I
Oh,
go.
I'm sorry.
So
Okay.
position 8 was,
Jail jury.
okay. Okay.
9 was a plea.
Mm-hmm.
10 was reset jail jury. 11 is null pros. 12 was a plea. 13 was null pros. 14 was a plea. 15 and 16 waived arraignment. 17 is also waived arraignment. 18 is reset for Thursday's SAP calendar. 19 is waived arraignment. 20 is waived arraignment. 21 is null pros. 22 is a plea. 23, waived arraignment. 24, we're holding on. 25 is reset for next Tuesday's SAP calendar, also for number 26.
Last name Jones.
27 is reset for next Tuesday, that's SAP calendar. 28. Are we holding on 28 as well? 28,
Yes.
we're holding on. 29 and 30 was released. 31 is a plea. 32 is a plea.
William.
33 is reset for next Tuesday's SAP calendar. 34, waived arraignment. 35 was a plea. 36, waived arraignment. 37 was null pros. 38 was a plea. 39 is reset for Thursday's SAP calendar for conflict attorney. 40 and 41 are reset for next Tuesday's SAP calendar, March the 11th. 42 and 43 are reset for next Thursday's SAP calendar. 44, what was the announcement on 44?
We did a non-negotiated plea, if I remember on that one.
That's correct.
Okay.
Yeah. Jones. Jones.
I just didn't write it on my calendar, thank you. 45 was a plea. 46 was a plea. 47 is null pros. 48, waived arraignment. 49. What's the announcement on 49?
We're waiting at 49.
Okay, thank you. 50 is reset, return to the division. 51 is null pros. 52 is a plea. 53 and 54 waived arraignment. And 55 and 56 are reset for Thursday's SAP calendar.
Okay, and who do we have here?
Position number 28, Jones.
Okay. And this is a negotiated plea, is that right?
Yes, sir. It's a negotiated plea for count 1 and count 2 is a no-lo.
Okay, good morning, Mr. Jones. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Say it again for me.
Your Honor.
Okay, yes, you can place your hand down. Thank you, sir. Ms. Tucker?
Yes, Judge. He's pleading to count 1, criminal trespass. That'll be 12 months to serve 32 days. Credit for time served, 16 days. Balance suspended. And to stay away from 761 Sidney Marcus Boulevard in Atlanta. That's a QT gas station. And he's pleading NOLO to count 2, possession and use of drug-related objects. That's going to be 12 months to serve 32 days. Credit for time served, 16 days. Balance suspended.
Mr. Chitai?
We stipulate to the facts, the venue and identity.
Mr. Jones, it's my understanding that in case 25 CR 0000844D, you wish to plead guilty to criminal trespass and NOLO to possession and use of drug-related objects. Is that right?
That's correct, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
I'm not.
You've been represented by counsel. Are you satisfied with his representation?
Surely.
You understand that you have a right to a trial by jury on these charges, and by pleading guilty and NOLO to them, you're giving up your right to a trial by jury?
I understand.
Has anyone forced or coerced you to plead guilty and NOLO?
No, sir.
I'll accept your pleas as negotiated, Mr. Jones. Good luck to you, sir.
How much?
Next, we can go to position number 24, blue chair. Mr. Hodges.
Okay.
How you doing, Your Honor?
I'm doing well, Mr. Hughes. Good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Can you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sure.
Okay, you can place your hand down, Mr. Hughes. Thank you. Ms. Falk?
Yes, Your Honor. On this position, state's recommendation is 12 months or 30 days, credit for time served 15 days. That's going to be balance suspended. Stay away from BP Food Mart at 4350 Jonesboro Road. The add-on, which is 25 CR 000772Y is 12 months served, 34 days, credit for time served, 17 days. That is from December 12th to December 13th of this year, and then December 15th to today. Balance probated. Stay away from Walgreens at 4617 Jonesboro Road. And we are also asking for a social worker visit prior to his release.
Why is the balance probated for the add-on?
Just in order to get the social worker visit done. After that, he can go non-reporting.
Okay. Mr. Chataya?
Well, 1 second, my client has a question. Your Honor?
Yes.
We wanted to know if we can have the social worker visit after he, so first that this is going to be a negotiated plea for both counts. My client wanted to know if he could get the social visit after he leaves jail.
I mean, that's fine. Isn't that how it normally works, that you all see the social? He needs a social worker visit for housing, is that right?
Judge, I believe she's there. She can talk to him right now, so.
That's why that's my understanding. That's why I asked for it to be before release and not after.
There's also no need for probation.
Yeah, then if it's going to be a social worker visit before release, then there's no need for probation.
Right. It was just,
Okay.
and again, it was just to ensure that it gets done. And after that, it would be non-reporting.
Okay, so why don't we do this? Why don't we just make sure that he sees a social worker, and I'll have it, both of these be, balance suspended.
Your Honor, she's right.
But he is to make sure that he sees a social worker before he gets, and I see you there. Good. Okay, so we've got a social worker that will see him. So he will be done with this. Okay, if we're all on the same page, Mr. Hughes, it's my understanding that in case 25 CR 000868Y, you wish to plead guilty to criminal trespass, and in case 25 CR 000772Y, is that also a criminal trespass charge, Ms. Falk?
It is.
Okay, you also wish to plead guilty to criminal trespass. Is that correct, Mr. Hughes?
Sir.
Are you under the influence of any drugs or alcohol at the present time?
Sir.
You've been represented by counsel. Are you satisfied with his representation?
Wonderful.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Correct, sir. I just have one question.
Hold on. I want you to ask your lawyer, ask your lawyer there.
Okay. Yes, sir. I'm sorry. He
Oh,
explained.
no, you're fine. I want to make sure that you understand everything. So as long as, yeah, so I don't mind that. Let's see, nobody has coerced you to plead guilty, have they?
Sir.
Okay. I will accept your plea as negotiated. Mr. Hughes, good luck to you, sir.
Thank you.
You're welcome.
Your Honor, we got petition number 40, William.
Okay.
Miss Kim, I just replied to you. I'll make that change.
Awesome. Negotiated, so Your Honor.
Okay,
That's it.
good morning, Mr. Williams. Let me know when you're ready, Ms. Kim.
Yes, we are ready, Your
You're
Honor.
ready? Good morning, Mr. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Good morning, sir. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Is that a yes? You have to answer verbally for me.
Oh, yes, sir.
Okay, very good. Thank you, Mr. Williams. Ms. Tucker?
Mr. Williams will be pleading to count one battery with the terms 12 months to serve 28 days, credit for time served 14 days, balance probated, to complete a 12-week anger management course, 40 hours of community service, to have no further contact with Courtney Jones, and to stay away from the Spondovitz restaurant at 1219 Virginia Avenue in East Point. Count 2, the simple battery will merge, and count 3, criminal trespass is 12 months to serve 28 days, credit for time served 14 days, balance suspended with that same stay away.
Your Honor, we stipulate for the purpose of the plea, can the probation be terminated upon completion of 12 weeks anger management and 40 weeks of community service?
I'll have it go to a non-reporting status, Ms. Kim, so you won't have to report and won't have to pay those fees.
Thank you.
Okay. Mr. Williams, it's my understanding that in case 25 CR 000854B, you wish to plead guilty to battery and criminal trespass. Is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Only under the influence of Fulton County Jail.
So that's a no.
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Williams. When you complete the terms, it'll go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation and have to pay those fees. Good luck to you, sir.
All right. Appreciate it.
You're welcome. Okay, does that take care of everybody this morning?
Yes, Your Honor.
Yes, Your
All
Honor.
right, very good. Thank you all. Let's see if you'll go ahead and get your paperwork to Ms. Strong as soon as possible. She'll get it to me and we'll get it back out so that we can get it back to the jail. Okay, anything further, Mr. White?
No, thank you, Your Honor.
We good? Okay, all right. Y'all have a good rest of the day. I'll see you next Tuesday. Thank you.
Bye-bye.
That's in that paper. I got it. By that time, say you say, sir, you take care of yourself, all right? Yeah, ma'am.